Welcome back to Defending the Windy City with David Drwencke. David is the founding partner of DRD Law, a Chicago-based criminal defense firm known for its courtroom strength, procedural mastery, and client-focused advocacy. I'm Evan Mack, and today we're continuing our three-part series inspired by Simon Sinek's Golden Circle. Last time we explored David's why, the deeper purpose behind his work. Today we're digging into how. How does DRD Law deliver on that mission in real, practical ways? This is how we fight inside the DRD Law approach. David, sir, welcome back.
Happy to be here. Thanks for having me.
Awesome. In the last episode, we talked about your purpose, your why DRD Law exists. Today, I want to ask how, and how did you bring this to life case by case?
Absolutely. Well, this is where my personal life and professional life, if there's a Venn diagram, they basically overlap. And what I mean by that is I am a huge just tech nerd. I love to be cutting edge. I love to be an early adopter. I just find it interesting. And I've always been that way from whatever the latest gadget or software or something that was coming out. I wanted to get it mainly because it was new. It was something to learn about. And it was the promise of making you more efficient or effective, or if it was just something new and fun to play with, if it was a video game console or something like that. Well, now that has bled itself into my law firm, where we are in the AI age at this point, and there's a great deal of other technology and tools that are coming out what feels like on an almost daily basis for lawyers in order to make yourself more efficient, more effective, in order to provide a better level of service to your clients. And I love it. Again, this is that opportunity for my personal and business lives to overlap here, and I invest in it heavily. So when it comes to the how, we understand why we do it. It's that grounded in the belief of human dignity and seeing people through to the other side. Well, how do we get them through to the other side? How do we get those results that the clients are paying us for, that they expect? That's why they're hiring us. And that's investing in ourselves, in myself, in my staff, in my team, in trainings and in software and in hardware. So we are leveraging artificial intelligence and the latest and greatest technology that's out there for us to parse through discovery in order to create medical chronologies, in order to put timelines together, to look for ambiguities and things that maybe the human eye might miss, and do so in brutally efficient manners so that as soon as discovery comes in, we have a summary within moments later that's leveraging things like a client portal, because communication is so paramount in all legal practice. We all have somebody that we're representing, somebody that we're accountable to explain, well, what are you doing? What's going on with the case? What are the updates? What do you think? Give me updates. Well, a client portal allows us to leverage technology to communicate with people 24 hours a day, 7 days a week, 365 days out of the year, where we can provide FAQs, what we jokingly call the Domino's pizza tracker, where somebody will actually be able to see where they're at. What phase of the case am I in? And what does that mean? What we're in the discovery phase. What is that? What demystify some of the jargon and the words and the word choice and so forth about what to expect. How long is this process? What happens during this process? What's my role in this process? And so we leverage technology from that initial phone call when somebody reaches out to the firm as a prospective client, either for themselves or a loved one, through onboarding, through actually representing that individual, all the way to closing a file out for trial or drafting motions and so forth. Technology and tools, we're leveraging them, utilizing tools that I trust plenty of my competitors don't even know exist, let alone use. And that is a competitive advantage. And that's an advantage for those who hire myself and my firm, because you're getting the best.
So when you're defending someone, what are the core values or standards that guide you in the way you approach your case from day one? We talked about in the previous episode about your upbringing, your family, and how they instill these values. But is that kind of what it is, or is there something from a legal perspective as well?
Well, that's where it starts is some empathy and caring and just genuinely, having some love for another person and understanding that they're going through probably the darkest and toughest part of their life. That's just having empathy and treating somebody with respect and respecting their dignity. That's a foundational why belief and why we do it. But then getting into the nitty gritty of like, well, the why and how do we do our job as an attorney in a criminal case is that it's evidentiary focused.
Hmm.
And, to go back to all my favorite lines, allegations are free, proof is very difficult. So, and I'm not worried what it is that you're charged with. I'm worried about what they can prove. What evidence does the state have that can convince a judge or a jury that you actually did what it is that they're accusing you
Mhm.
of? So, okay, I know what you're charged with. Great. That doesn't move the needle for me necessarily as far as like how much harder or less hard somebody would fight. I take every case deathly seriously because each case is one of one for my client.
Right.
I might have, multiple files and multiple clients because of the nature of running a business, but for my client and their family, it's one case. It is their case. It's what they wake up every day thinking about. It's what they more likely than not lay their head on their pillow thinking about when they go to bed. And that's not lost on me. But beyond that, it's now the evidence. I want to see what the state has. And there's a metaphor I'll use with many of my clients is that it's like playing a hand of cards where the state actually has to show us their hand before we're
Mhm.
really compelled to do much of anything or show them our hand or what our defense is going to be or what our witnesses may say. And again, because it's a hand of cards, there are plenty of cases where I look at it and I raise an eyebrow thinking, well, this is 9-10 off suited. They've got effectively nothing here. And there's really no opportunity for a surprise from this state. And then are there times where I look at this and go, uh-oh, like this is a royal flush. This is for the state. This is not good for us that they have DNA, they have video, they have eyewitnesses, they have, a pretty unassailable case. Well, depending on what type of hand the state has, well, then we know what direction we need to go in. Is this a triable case? Is this one where there's a legal technicality because I've looked at the evidence, the discovery, or is this one that we need to negotiate? Where, listen, trial is not in your best interest because we're unlikely to be successful. And we need to try to get a better deal out of this rather than going to trial and suffering the full force of what the punishment could be by going to trial. And what I hope and what I and my staff do our best to do is earn the trust of our clients by
Mhm.
them understanding our why, appreciating how we're doing this, and that we build up the rapport and trust and through communication, like again, using that client portal and the technology, that when we get to that end game on a case and we're
Mm.
providing our legal analysis saying this is why I think we can go to trial, or unfortunately, having that tough conversation about this is why you probably don't want to go to trial, or you definitely don't want to go to trial, that the client, the client's family believe that and say, yes, David has done the work. David's team has done the work, that what he's telling me is the truth, that we're not trying to just rocket you through the system and close a case and take the first available plea agreement and be done and move on to the next one. Because that's what many clients believe is happening with the public defender's office. And a lot of times that probably is true, which is unfortunate, but you've hired us to do a job. And I trust you've hired us because you believe we're going to do it the right way and for the right reasons. But at the end of the day, we're earning that trust, and that the how we're doing it allows us to provide the best level of communication, best level of service, so that when we're getting to the end game and we're advising to go one way or another, and then again, if it's trial, leveraging tools to present yourself in the best light possible,
Right.
that you can trust that that's the right answer.
And keeping with the how theme, how do you ensure you're building a defense that's, both legally sound and true to the principles that you stand for, sir?
Sure. And again, that's being able to leverage the tools that we have. And it's a combination of things. We're never going to get away from the fact that somebody with experience, be it myself or some of the other attorneys that work at the law firm and paralegals and so forth, we're going to look at this and apply our own brains and look at this and years of experience and hundreds of trials in our back pocket, that we can look at, well, what is successful and what isn't. Again, a line I will use with clients a lot. I will come up with an argument. Don't worry about that. I have a vivid imagination. I'm creative.
Mhm.
I will think on my feet. I'll get up there and soft shoe for the jury if that's what I got to do.
Right.
But is it persuasive? Does it get the result that you want? Which, if we're going to trial, is the not guilty, or some limited examples. Maybe we're looking for a lesser included offense. But that comes from being able to do the due diligence, to do the prep work, to then apply experience, to apply our knowledge that no AI, at least not for the foreseeable future, can do. But we leverage the tools so that we can look at this and make things make sense, to get through hundreds, if not thousands of pages of discovery through what can be grand jury transcript, medical records, police reports, witness statements, things that are just recorded. So we have video and audio that we have tools that can turn that into a transcript, and ways we can excise out very specific statements or even search within a video to pull out, well, how many times did my client deny being involved? Answer: 52 times. It's like, well, that's incredible. I didn't actually have to watch this 3-hour video and do a tally for every time my client did something. I can leverage technology to do that so that we work more efficiently, more effectively. When it comes to our legal research, there are tools that are, I mean, just astoundingly impressive, where I can feed in my opponent's brief and it will pull out
Wow.
to make sure, did they cite things correctly? Did they actually quote things correctly? Even if the quote is correct, is that really what the case stood for?
Wow.
And even make suggestions about possible arguments that, hey, David, we know you've been doing this for over a decade. Here, you've argued A, B, and C. Here are some other ideas. Did you consider D, E, and F? And again, these are tools, some of which quite literally were released this past week, that as soon as it went live, I signed up. And yes, there's a cost associated with that, a monetary cost. There's a time cost in becoming an expert on how to leverage that tool.
Right.
But my clients deserve that. They should require it. Now, a lot of clients don't know that some of this stuff exists, and that's why I think a lot of other private attorneys can get away with not using it, because what you don't know can't hurt you. At least that's the old saying. But in reality, it can. I actually find it to be malpractice not to be utilizing
Mhm.
these tools, because clients deserve it. That if these tools exist and they can help you do your job better, or again, not just being more economical and being more efficient, that matters. Those are words I use, but it's actually doing a better job for your client. That is a requirement. You should go on and pay for these things. You should be up to speed on the latest technology. You should invest in these things. And the fact of the matter is, most do not. So that's one advantage of hiring myself and hiring my firm over dealing with others.
Some cases involve serious charges, as emotionally charged situations. How do you stay focused on your process instead of kind of getting wrapped into all the chaos and the hoopla and the spectacle of the thing?
Sure, and that does happen depending on the case, because there's people on either side now, when especially if it's maybe a violent crime or a sex assault or something like that.
Yeah.
There are people on the other side that are alleging that my client has done something, and they're emotional, and rightfully so. They believe that their family member was killed in the worst case scenarios, or was assaulted in some way or battered or whatever. And of course, they're going to support their family member, their injured party. I respect that. And of course, now my client has their own family members, and they support their family member that they didn't do this, or it's a lie, or it's an exaggeration, or what it may be. And when you're in court, sometimes the two sides meet, and it's not always pretty, it's not always professional, and it can feel like a Jerry Springer episode or something like that sometimes. And of course, the emotions are running high. Like even with my own client, like they realize they're facing, at least potentially, a very long time in prison and having a criminal record, or having to register on the sex offenders registry, among other things. And it's terrifying,
Yeah.
understandably so. If the shoe was on the other foot, I probably would feel the exact same way, and it'd be nerve wracking. But it can be difficult to not stay in the emotions, and to get into the weeds of like, well, they're just lying. Why can't we just go to trial today? This is nonsense. I shouldn't be dealing with this. And another line I use all the time is say, well, two things can be true at the same time. Is
Yep.
that this person is lying. I agree with you. We're going to defend you and your rights, but we're just not there yet. We have to work our way through the process, and it is slower than it needs to be. I'll acknowledge that. But it's like, let me focus on what my role is in this, and that's deciphering and parsing through discovery and evidence. Discovery, the word we banter around all the time. It's just another word for evidence. It's, in a given case, it can be different things. We're talking about DNA and fingerprints and gunshot residue tests and medical records and witness statements, what are photos and videos. There's different stuff, different discovery on different cases, but we need to parse through that. We need to see everything that the state has before we can make an educated decision. Do we want to do a jury or a bench trial? While that's ultimately my client's decision, for me to be able to provide legal advice, well, we need to know, what kind of defense are we running? Is this more fact-based? Is this getting a little bit more into the emotions? Is it hyper-technical and more of like a legal argument applied to our facts? Well, different defenses, different situations call for different advice. And so it's letting us work our way through the process to leverage our tools, to leverage our processes in order to get that best result for the client.
So what's a good outcome for you? Not just on paper, but in terms of how it affects a client's future. Is it wins? Is it knowing that you did your best? That can moral victories, play a part? What's a good outcome to you?
Sure. Well, and being a competitor, I've never been one for moral victories. And sometimes there's a joke sometimes, among defense attorneys, especially on particularly difficult cases or ones that maybe we're not advising to go to trial. It's like, listen, I can only see one path forward, and that's likely a guilty verdict. So the moral victory that we would joke about or be even serious about is like, well, how long can I have the jury out deliberating on this? So long as they don't come back 5 minutes just saying my guy is guilty, it's like, good. I at least gave them something to think about. I made this more difficult for the state. There's something to be said for that, but that's not where my brain goes, because it's a results business. It's a service-based industry, and where I work and live each and every day. So moral victories don't do my client any good. If they're found guilty, they're found guilty. It's a binary outcome. It's a guilty or not guilty at trial. That's where cases have to resolve. So I focus on the results. And I do say that victory can look different for different cases, meaning, are there those that go to trial and not guilty is the goal? And like, that is the path forward. That is the victory. Yes. And I go to trial. This sounds more like a sales pitch. I go to trial more than anyone in Cook County. And I'm confident in that by sometimes maybe even a multiple. We've been in trial 13 times this calendar year, and we have more than that set to work out through the rest of 2025. Wow. And we're heading into the fall right now. So we go to trial a lot. I am known as a trial attorney. I think in part that's the type of clients that I attract, are those who want to fight, who want somebody who is competent in trial, who knows the evidentiary rules. And I don't want to call them tricks, because that feels a little disingenuous, but the best way to present evidence at a trial to get the best result. So I live for that. I love it. Like, that's the best payoff for me, my own personality. Like, I like the theatrics of trial. I like the stakes of trial. I like the pressure that's associated with trial. Like, I thrive on that. I enjoy it. But that's not appropriate for every case. There are other cases when we look at the evidence and say, you do not want a trial. You don't want this smoke. I'll say that to the clients, like, because it's going to end poorly. Do you really want to suffer the higher end of the sentencing range because we chose to beat our heads against a wall rather than work something out? And in those cases, it's mitigating the damage. It's lessening. It's like, okay, you're looking at 6 to 30 is your sentencing range. Well, maybe we convince the state through negotiations and providing mitigation just being good stuff about my client, to say, okay, come off of that class X felony, come to a class 1, come to a class 2, where it's a night and day difference in the sentencing range. And I mean, there are examples from just this past week. Client charged with a class X felonies look at 6 to 30 years in prison to be served at 85%. We don't have to get into the weeds on that. Well, we were able to convince the state through mitigation and negotiation to drop it from the class X, the most serious felony we have, to a class 2. Well, what's the range on a class 2? 3 to 7 years at 50%. Wow. Was a huge difference in what kind of time he was looking at and what time or when he'd be able to get home to see his loved ones. And that was the appropriate way to go. Trial would not make any sense. We would not win at trial. There was evidence, video evidence, like it was kind of unassailable. We're not going to win that case. So what's in our best interest? Negotiating, and then being able to leverage relationships and mitigation software, among other things. We were able to get a fantastic result, and that had nothing to do with trial. And that's actually not getting a not guilty. He's actually going to accept responsibility and plead guilty. But that is
Wow.
a tremendous outcome given the evidence, given the situation we find ourselves in.
That's wonderful. But finally, how do you know when your process is working? What tells you that DRD laws, how is it really making a difference? That's probably my final how. How do you know you're making a difference?
Well, I'd say there's two. There's the overly technical, staying in the weeds of assessing the evidence, and that's talking to jury members after a trial. And I will do 100% of the time, whether we win or lose. I will always go back, assuming the jury will stay and talk to me, and ask them, "Oh, hey, what moved the needle here? What was kind of the
Oh
ultimate
wow.
issue? What bit of evidence, took you one direction or the other?" And
Right.
gladly and happily, and knock on wood, I've been very consistent in being correct on that. The jury will come back. It's like, well, this is why. This is, the state didn't have this and that. We agreed with your argument. This is why we found him or her not guilty. Or this specific bit of evidence, like we couldn't get over this. And this is why we ultimately ruled,
Wow.
against him and found him guilty. And why that's so important is because if I want to win for the right reasons, that I assessed the evidence correctly, our arguments were correct and obviously resonated with the jury. If we're going to lose, it pains me and it sticks with me forever. But it's like, did we lose for the right reason? Did the jury assess the evidence the correct way? And did we lose because I assessed it correctly myself? And again, fortunately, I have thus far. The jury comes back and they're like, yeah, it was this bit of evidence. Like, okay, yeah, that's what I thought too. That was the thing we were wrestling with and trying to fight against, but I knew that was going to be a sticking point. The other is just it's reviews. It's from clients and their family members that I'm proud of. I don't even know where we're at 140 some odd reviews of happy clients who have come back and said, "Hey, I've worked with this firm. I've worked with the attorneys. That what they say on their website, what they say in their ads, what you hear on social media or on podcasts bears out and is true. They communicated with me, they treated me with respect, and they got the result that I wanted." And that includes clients who have taken time, who have
Mhm.
pled guilty, that we've still gotten positive reviews because they were happy with the result. They were happy with our process and how they were treated throughout that process. And that is encouraging. That, again, that makes me feel good getting back to the why of what we're doing for people and why we do it is to get that positive feedback, to get a 5-star review or to have somebody reach out and get a text a year or two later. And that it doesn't happen as regularly maybe as I would like, but I've had clients who will reach out and say, "Hey, I'm thinking about you. I just got a new job. Thank you so much. Like this wouldn't have been possible, but for, what you're able to do for me in the case." And that makes you feel really good.
Incredible, David. Good stuff, man. Very informative, very educational, brother. I really appreciate your time.
Thank you. I appreciate being here.
And thank you all for listening to Defending the Windy City with David Drwencke. In today's episode, we explored the how behind the mission, what makes DRD Law's defense strategy precise, provocative, and deeply personal. If you're facing criminal charges and want a team that brings both heart and horsepower to the courtroom, visit drdlawllc.com to learn more. And don't forget to like, subscribe, leave a review if you found this information helpful. Thank you so much for watching, and we'll see you in the next episode.